Today on Rip and Learn, we're going to talk about Korematsu versus the United States in 1944. It's a Supreme Court case that is really important, and based on the year there, you can probably guess what this is about. And I've put the main topic here, the main idea is that this is the importance of dissent. And I'll explain what all that means. So some vocabulary that you might need to know if you don't already know. So some things that you should know: SCOTUS is the Supreme Court of the United States, SCOTUS. A petitioner is a person who is petitioning or asking or pleading the government or the court to hear their case. The way that I remember it is pleading starts with a P, a petitioner, a person asking, right? And then another word that pops up a lot is indeterminate, which the official definition, not clearly or exactly decided or vague. If something is indeterminate, if it's for an indeterminate amount of time, for instance, there's no telling how long it will be. So first off, just so you can get an image in your head, this is Fred Korematsu with his parents, and you can see that they have a family nursery, and they did quite well from my understanding. All of the links that I have on these pages, on these slides, I have in the description, so feel free to, go down the rabbit hole to your heart's content. Some other information that you'll need to understand is the whole, removal of Japanese Americans and people of Japanese descent and from Japan themselves, moving them from quote-unquote military areas. And this is a map that, again, I'll put in the description so you can play around with it. You can zoom in. It's going to be really high quality, so you can see specifically. And again, note how much of the West Coast this is. This is the entire West Coast plus southern Arizona. That is a massive amount of area. Also, in case you're wondering, okay, I've heard about this. Where did they put these people? Here is a map that has a variety of places. Again, the link is in the description. So there is a website called Oye. It looks like Oyez, but the actual pronunciation I've learned over time is Oye. So let's look at the facts of the case. Okay, I'll just read it because you're probably looking at the card opening. So, in response to the Japanese attack on Pearl Harbor during World War II, the U.S. government decided to require Japanese Americans to move into relocation camps as a matter of national security. President Franklin Roosevelt, FDR, signed Executive Order 9066 in February of 1942, 2 months after Pearl Harbor, the attack on Pearl Harbor, okay? A Japanese American man living in San Leandro, that shouldn't be hard, Fred Korematsu, chose to stay at his residence rather than obey the order to relocate. Korematsu was arrested and convicted of violating the order. He responded by arguing that Executive Order 9066 violated the Fifth Amendment. The Ninth Circuit affirmed Korematsu's conviction. So the way that this works is when you have a case, it'll work its way up the system if need be. So when a decision is made on a case, you can appeal it, which means that, hey, I don't think that went appropriately. Not that, oh, I'm a sore loser. But to appeal a case means that you think the government erred. Like there was an error in that decision. So then it made its way up to the Ninth Circuit, which is, again, a higher level court. And then it made its way up to the Supreme Court. So this takes a long time. Normally when a court case goes to the Supreme Court, this is over many, many years. It's not immediate. It takes a lot of times and a lot of different levels of court to hear it. There are exceptions, but generally speaking, that's how it goes. So the main question in this case, it's not about whether or not he disobeyed the order. The question is, was the order itself problematic? That is something else to understand when we're talking about Supreme Court cases. It is not about normally whether this person is guilty or innocent. Normally, that's pretty easy, ish, okay? But the main question in a Supreme Court case goes beyond guilt or innocence. It is this law constitutional in itself? So when we look at the question that the court was really focusing on here, did the president and Congress go beyond, same thing, their war powers by implementing exclusion and restricting the rights of Americans of Japanese descent? Please notice too, this says Americans. of Japanese descent. Many of these people were American citizens. Some were straight on, Japanese citizens or had immigrated from there. But a lot of these people who ended up in these camps were American citizens. So, spoiler alert, okay, as for what did this decide, okay, what did the court decide? Well, it was I wouldn't say a split decision, but kind of, right, 6-3 for the United States, meaning that they agreed that the United States did have this power and this ability under wartime scenarios to be able to exclude citizens and remove citizens that they felt were in a militarily important situation. Okay. Again, it explicitly says the exclusion order applying to Americans of Japanese descent was lawful. And on Oye, you can see who agreed with the decision and who did not. So, whenever you're studying a Supreme Court case and you're like, why did they say that? Or how is that the reason? Right? Because you'd think, okay, they're putting American citizens, they're removing American citizens from their home, they're removing American citizens from their businesses and their livelihoods, and somehow that's okay. Like, how does that make sense, right? And so the way that you figure that out is you read the opinion of the court. The opinion is a written document, normally, I think, made by the Chief Justice, the one who is the top dog. And I don't think that that's always the case, but I think generally speaking that's normally the case. The opinion here was written by Justice Black. So justice is like their title, Supreme Court Justice, not judge. Normally a judge's title is judge, but a Supreme Court Justice's title is justice. So in the opinion written by, again, the Justice Black, the court ruled that the evacuation order violated by Korematsu was valid, meaning it was that law was correct, and yes, of course, he did violate it. Okay, we already established that. The majority found that the executive order did not show racial prejudice, but rather responded to the strategic imperative of keeping the U.S., and particularly the West Coast, the region nearest Japan, secure from invasion. The court relied heavily on a 1943 decision, Hirabayashi versus the United States, which addressed similar issues. Black argued that the validation of the military's decision by Congress merited even more deference. So it is important to read the conclusion, and it is important in this case in particular, for me, more important to read the dissent. So I have some information here. We have the opinion of the court by Justice Black. We have the concurring opinion. A concurring opinion is another written little essay by another justice who agrees with the decision of the court but wants to add their 2 cents or perhaps their perspective. So here we have the opinion of the court, again, an essay written by the Supreme Court, I believe the Chief Justice Black, and then we have concurring, another very small, very short concurring opinion by Justice Frankfurter, and sorry, you just don't see names like that anymore. Frankfurter, concurring, so again, a little bit where he just wanted to add his 2 cents to his opinion, and he's saying, yeah, I agree with that, and blank, okay? So as for why did he feel like he needed to add his 2 cents, he said, quote, the martial necessity arising from the danger of espionage and sabotage, unquote, warranted the military's evacuation order. So he just wanted to specify why he thinks that law was okay. Then we have 3 dissents. So dissents are people who are on the court and do not agree with the majority opinion. And the majority. So the opinion of the court is also known as the majority opinion. Okay, an opinion in this context is always going to be an essay explaining their reasoning. A lot of times it'll also explain historical context and stuff like that. Now, all 3 of these dissents are really interesting and really, really a good read. So let's talk about this real quick. So Jackson Justice Jackson dissented. Again, to dissent means to disagree, arguing that the exclusion order legitimized racism that violated the Equal Protection Clause of the 14th Amendment. And on this channel, I have already talked about the Equal Protection Clause because it is so important for so many different reasons and so many different cases. So, Chief Justice Hugo Black, so I was right. Chief Justice is the guy or girl, but we never had one, that's a girl, in charge. I think it's normally based on seniority, but I think they also have to agree on this, but traditionally they do that. Anyway, so I read the opinion, I read the concurring opinion, and then I read all the dissents. And I think they're really interesting. So what I've done is I went through them, I highlighted the important parts, condensed it, and put it in this PowerPoint. So it'll be mostly me just reading off the slide, but again, I have the card opening on the other side so that you can see. Okay, so you don't have to read it. Now, some key points of the opinion, the majority opinion, all right? Assembly and relocation centers were separate, and meaning assembly is separate from relocation, and their validity is not an issue in this proceeding. So we think of Korematsu as somebody in 2025. A lot of times we think about Korematsu versus the United States as a case regarding the concentration camps, or I should say internment camps, or however you want to put. We will talk about the wording in one of the other justices' opinions. But to ship off Japanese Americans, again, Americans, to camps was not actually the main thing that the justices were focusing on. The dissents do, but the opinion of the court does not, and that is an important thing. The petitioner, Mr. Korematsu, was convicted for remaining in his town, a quote-unquote military area, contrary to Civilian Exclusion Order number 34, which directed all persons of Japanese ancestry should be excluded from that area. Again, they're not saying that he was not guilty of this, okay? No question was raised as to the petitioner's loyalty to the United States, which is worth note. And it should be noted that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect, and that courts must subject them to the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. What this means to me is that they understand that this could be interpreted as racial discrimination. But they're like, well, but in wartime, though, is different. I hope Donald Trump does not get any ideas, if you know what I'm saying. The petitioner, again, Mr. Korematsu, so anytime they say the petitioner, they will not, normally they're not going to say Korematsu. They will say the petitioner. The petitioner knowingly and admittedly violated the exclusion order. And then the opinion references the SCOTUS case Hirabayashi versus the United States 1943 multiple times. Okay, where this is called legal precedent. Precedent, Precedent, not president. Precedent means something that has happened in the past that informs the future. So that just makes sense, right? If similar circumstances happen, you should get similar results. Otherwise, that's not justice. So they reference Hirabayashi, where they sustained a conviction obtained for violation of the curfew order for all persons of Japanese ancestry in prescribed West Coast military areas to remain in their residences from 8 p.m. to 6 a.m. As is the case with the exclusion order here, that prior curfew order was designed as a protection against espionage and against sabotage. There is a difference between a curfew and removing people from their houses and businesses to an unknown location for an unknown amount of time. But this was the case that was most related to the case at hand, and that is why they chose it. In this case, the petitioner challenges the assumption, again, the petitioner meaning Korematsu, challenges the assumptions upon which we based our conclusions in the Hirabayashi case. He also urges that by May by May 1942, when Order Number 34 was promulgated. All danger of Japanese invasion of the West Coast had disappeared. We are compelled to reject them. Again, fair. That wasn't that much farther after Pearl Harbor. And we know in 2025 that they didn't end up attacking us again or having real espionage or sabotage problems, but they didn't know that in 1944 or 42 or whenever, because we were still at war at that time. They acknowledge that most of those of Japanese origin, we have no doubt, were loyal to this country. So again, they're talking about espionage and sabotage, but at the same time, they're trying to cover their butt by saying, we know that most of them are totally fine, but, and that was a big but. As an attempt to give some legitimacy to their fears of Japanese sabotage and espionage, they put this: approximately 5,000 American citizens of Japanese ancestry refused to swear unqualified allegiance to the United States and to renounce allegiance to the Japanese emperor, and several thousand evacuees requested repatriation to Japan. Repatriation would be to send them back. Now, there's a lot of context needed for that first part of American citizens of Japanese ancestry refused to swear unqualified allegiance to the U.S. That is a very complicated thing, and that can be a whole video or more in and of itself. On the surface, it seems like that's a problem, but when you look at the document that they gave them, you can see why. And again, if you take into consideration that, hey, this government is now becoming hostile to me and is trying to kidnap me and destroy my livelihood, yeah, you know, that context can be helpful. To continue, we are not unmindful of the hardships imposed by it, meaning the order, upon a large group of American citizens, but hardships are a part of war, and war is an aggregation of hardships, meaning it's to aggregate something means to make it all come together. All citizens alike, both in and out of uniform, feel the impact of war in greater or lesser measure. Citizenship has its responsibilities as well as its privileges, and in time of war, the burden is always heavier. Compulsory exclusion of large groups of citizens from their homes, except under circumstances of direct emergency and peril, is inconsistent with our basic governmental institutions. But when under conditions of modern warfare, our shores are threatened by hostile forces, the power to protect must be commensurate with the threatened danger. So again, they're saying, yes, this is a problem, but everybody has a problem. This has like a big all lives matter vibe to me. Because it's like, war is hard for everyone. Like, some people just have to carry the burden bigger than others. Again, it also kind of sounds like Animal Farm. To continue, they bat down a claim that the orders were contradictory. We will see that again in the dissent. So just for now, just put a pin in that. They re-emphasize that the only issues framed at the trial related to the petitioners remaining in the prohibited area in violation of the exclusion order. Not the relocation, not the incarceration. Again, we'll talk about euphemisms. It's not that. This case is about whether the exclusion order of staying in this location was lawful or not. Some who did report to the assembly center were not sent to relocation centers, but were released upon condition that they remain outside the prohibited zone until the military orders were modified or lifted. This illustrates that they pose different problems and may be governed by different principles. What they fail to say is how many were released and let free. Because why, right? If it was a significant amount, wouldn't you put that in there? So it didn't make... It's one of those things where, like, it should set off your BS detector. They claim that there were separate provisions of the separate orders. These separate requirements were that those of Japanese ancestry, 1, depart from the area, 2, report to and temporarily remain in an assembly center, 3, go under military control to a relocation center to remain there for an indeterminate period until released by the military authorities. Since the petitioner has not been convicted of failing to report or to remain in an assembly or relocation center, we cannot in this case determine the validity of those separate provisions of the order. To do more would be to go beyond the issues raised and to decide momentous questions not contained within the framework of the pleadings or the evidence in this case. Some of the members of the court are of the view that evacuation and detention in an assembly center were inseparable. That is really, really, really important, which is why I put the whole freaking paragraph there. Again, we normally think of Korematsu as being a case where it is about the concentration camps, and that this case made it so that internment camps, again, whatever you want to call it, that these camps were illegal. That is not what this case says. This case, in my opinion, was faulty and too limited, because it is only about the exclusion order. It is only about the military zone. It isn't about the most important part, which is them keeping them in a place for an indeterminate amount of time. Now, what they say here at the very bottom, which is why I didn't end the paragraph here, I put the ellipsis here to skip some, but then get to the important part. Some of the members of the court are of the view that evacuation and detention in an assembly center were inseparable. So what you'll see is in the dissents that's their argument, is that relocation to where, right? Like that is inherently part of the question. It is not simply that he violated the order of staying there. Well, where was he going to go? And therefore, it is inseparable. But from the majority opinion, they wanted to focus only on the thing that, to be fair, the issue was brought upon them. But again, how you interpret that changes the results. And that's why, in my opinion, the majority opinion is very different from the dissenting opinions. The assembly center was conceived as a part of the machinery for group evacuation. The power to exclude includes the power to do it by force if necessary, and any forcible measure must necessarily entail some degree of detention or restraint. So they admit that. But whichever view is taken, it results in holding that the order under which petitioner was convicted was valid. This is the legal chess game. This is the legal word game. It's a game. And their interpretation, however limited, is valid and fair. And the dissents are also extremely valid and fair because of their interpretation of what's going on. So it's interesting. Our task would be simple, our duty clear, were this a case involving the imprisonment of a loyal citizen in a concentration camp because of racial prejudice. We are dealing specifically with nothing but an exclusion order. To case this case into, I think I made a typo, to case this case into outlines of racial prejudice without reference to the real military dangers which were presented merely confuses the issue. Korematsu was not excluded from the military area because of hostility towards him or his race. He was excluded because we are at war with the Japanese Empire. And then they close. There was evidence of disloyalty on the part of some. The military authorities considered that the need for action was great and time was short. We cannot, by availing ourselves of the calm perspective of hindsight, now say that at time these actions were unjustified. What does he mean by this? He's saying that hindsight is 2020, which means that we know now that there was no sabotage. We know now that there was no attacks or espionage or whatever. But we could not have possibly known that in the moment. So that's what he's saying. Again, fair. That's totally fair. I'm not saying this is stupid. I'm saying that makes total sense. Then, okay, so that's the end of the majority opinion. Then I told you, Justice Frankfurter, he has a concurrence. That means that he agrees with the majority opinion and he just wants to add something. So what does he add? The provisions of the Constitution to enable this country to wage war are as much of a part of the Constitution as provisions looking at a nation at peace. The war power of the government is the war power of the government is the power to wage war successfully. Therefore, the validity of action under the war power must be judged wholly in the context of war. So I think he just wanted to say, I'm not racist. This is really a military situation. And what you'll see in the dissents is that they talk about the racism and the military part. They're not saying that, there was no threat. Because there was. But again, at what cost are we dealing with these? That's the main question. Spoiler alert. Okay. The first dissenting opinion is by Justice Roberts, and I love it. All three of these dissents are really good, and I highly recommend reading them in full. They are very, very well done and very interesting. His first paragraph, Justice Roberts, only one sentence. He says, I dissent because I think the indisputable facts exhibit a clear violation of constitutional rights. If that's not a solid opening, I don't know what is. It is the case of convicting a citizen as a punishment for not submitting to imprisonment in a concentration camp based on his ancestry and solely because of his ancestry without evidence or inquiry concerning his loyalty and good disposition towards the United States. Again, great sentence. The petitioner is a native of the United States of Japanese ancestry who, according to the uncontradicted evidence, is a loyal citizen of the nation. He pushes back on the claim from the main opinion, saying that the orders were clear and not confusing, and also that the claim the military had an urgent need to create this order. Quote, critical attention must be given to the dates and sequence of events. So then he goes into like this multi-paragraph timeline where he starts with the declaration of war on Japan on December 8th, 1941, because Pearl Harbor was attacked December 7th. Then he talks about a few things, including the issuing of Executive Order 9066 in February of 1942, adding, again, more events. And then the exclusion order in question was made on May 3rd, 1942. He calls out the absurdity of calling the wording of Proclamation Number 4, quote, it is necessary in order to provide for the welfare and to ensure the orderly evacuation and resettlement of Japanese voluntarily migrating from military area number 1 by this footnote. So he says, to reword what I'm saying here, he put this quote from Proclamation Number 4 in his opinion, and then in a footnote, like in a citation, okay, it was hilarious because he says this, the italics in the quotation are mine. The use of the word voluntary exhibits a grim irony probably not lost on petitioner and others in like case. Either so, or its use was a disingenuous attempt to camouflage the compulsion which was to be applied. So either they are being ironic on a very important topic, or they were just trying to basically lie to people by saying it was voluntary. But it obviously is not voluntary, so he's calling it out. He elaborates the confusion claimed by the petitioner. Quote, he was forbidden by military order to leave the zone in which he lived. He was forbidden by military order after a date fixed to be found within that zone unless he were in an assembly center located in that zone. So there was a military order that said that you're not to leave. And then a couple of days later, there was another order that said you are not allowed to leave. Or no, you're not allowed to be there. So the first one was you're not allowed to leave, and the other one was you're not allowed to be there. Well, which is it? An assembly center was a euphemism for a prison. No person within such a center was permitted to leave except by military order. So again, he's talking like he brings this up as internment, concentration, prison. There's like a bunch of different words, but they can't leave. Okay, so it's prison. The only way he, petitioner Fred Korematsu, could avoid punishment was to go to an assembly center and submit himself to military imprisonment. So in turn, the petitioner did nothing. Fair. If we were in that position, we'd probably do the same thing. On March 18, 1942, the president had promulgated Executive Order 9102, establishing the War Relocation Authority, under which so-called relocation centers, a euphemism for concentration camps, were established. He, Korematsu, was illegally held in custody. So again, this guy, I like it. He is calling them out. Relocation center, assembly center, all these things. It's a euphemism. A euphemism is a nice word for something not so pleasant. And he's just calling it like it is. The government has argued in this case as if the only order outstanding at the time the petitioner was arrested and informed against was Exclusion Order number 34, ordering him to leave the area in which he resided. That argument has evidently been effective. The opinion refers to the Hirabayashi case to show that this court has sustained the validity of a curfew order in an emergency. The argument then is that that exclusion from a given area is of the same nature, a temporary expedient made necessary by a sudden emergency. This, I think, is a substitution of a hypothetical case for the case actually before the court. The civil authorities must often resort to the expedient of excluding citizens temporarily for a locality. The drawing of fire lines, the removal of persons from an area where a pestilence has broken out are familiar examples. But the facts above show that the exclusion was part of an overall plan for forcible detention. Again, nobody give Trump any suggestions or hints here, okay? The two conflicting orders, one which commanded him to stay and the other which commanded him to go, were nothing but a cleverly devised trap to accomplish the real purpose of the military authority, which was to lock him up in a concentration camp. Again, highlight, underline, italics, that is solid stuff. Why should we set up a figmentary and artificial situation instead of addressing ourselves to the actualities of the case? Okay. The Murphy opinion is so freaking good that I want to read the whole thing. So I'm not going to read the whole thing right now. I'm going to put that in another video because it's going to be long, but it is so good. It's really good. So this guy, eyebrows, also he has like a cool backstory. If you look him up, pretty interesting man. We'll read his later. But the third opinion, the third of three dissenting opinions, is from Justice Jackson. So what does he say? He says stuff that's similar but different. Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity, meaning he's a native citizen, and a citizen of California by residence. No claim is made that he is not loyal to this country. Korematsu has been convicted of an act not commonly a crime. It consists of merely being present in the start whereof he is a citizen, near the place where he was born and where he all his life has lived. That is a solid claim. The military orders were so drawn that the only way Korematsu could avoid violation was to give himself up to the military authority. This meant submission to custody, examination, and transportation out of the territory, to be followed by indeterminate confinement in detention camps. Again, that word indeterminate means you don't know how long. I put a star in here because it's really important. And again, relevant to current events. Okay. A citizen's presence in the locality, however, was made a crime only if his parents were of Japanese birth. Had Korematsu been one of four, the others being, say, a German alien enemy, an Italian alien enemy, and a citizen of American-born ancestors convicted of treason but out on parole, only Korematsu's presence would have violated the order. The difference between their innocence and his crime would result not from anything he did, said, or thought different than they, but only that he was born of a different racial stock. If any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. Okay, star, underline, italics, okay? But here is an attempt to make an otherwise innocent act a crime merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race from which there is no way to resign. Seems relevant. In regards to the military actions, they said, when an area is so beset that it must be put under military control at all, the paramount consideration is that its measures be successful rather than legal. The armed services must protect a society, not merely its constitution. I cannot say, from any evidence before me, that the order of General DeWitt, the guy who gave the military orders, were not reasonably expedient military precautions, nor could I say that they were. But even if they were permissible military procedures, I deny that it follows that they are constitutional. So what he is saying is, I understand that the military has a duty to protect people. I understand that I'm not a military person. But I am a Supreme Court justice who follows the Constitution and examines things from the perspective of, is this constitutional or is this not? And this is not. How does the court know that these orders have a reasonable basis and necessity? No evidence whatever on that subject has been taken by this or any other court, meaning the lower courts, as it made its way up the chain. I have another typo. This is a sharp controversy as to the credibility of the DeWitt report. Again, that's the general. So the court, having no real evidence before it, has no choice but to accept General DeWitt's own unsworn, self-serving statement, untested by any cross-examination, that what he did was reasonable. Let's dissect that for just a second. So let's put it into regular words. He is saying that they have to trust General DeWitt's statements about why he made this executive order, and he did not give this statement under oath, meaning that he can't be charged with perjury if he lies. He could have just completely lied, and there would be no consequences to that. Further, if he's making a statement about his own behavior, and his own behavior or his own military orders is under question, then he has reason to lie. Further, he says that this is untested by any cross-examination. Cross-examination is what you see on TV and movies where you have a lawyer questioning somebody on the stand. That person on the stand who's sitting there in the little box next to the judge, that person is under oath. They have to swear that they're going to tell the whole truth, but the truth, so help me God, right? So what goes one step further beyond a sworn statement is that they are questioned. They are asked questions, and they have to answer those questions, and they have to answer those questions truthfully. So there's a whole bunch of things here that are normally put into place to examine the truth, to figure out, is this actually a justifiable action by the government? And there was no way for them to verify this. We have to trust the information by the guy who made this problematic order. He's saying that's problematic in and of itself. In the very nature of things, military decisions are not susceptible of intelligent judicial appraisal. They do not pretend to rest on evidence, but are made on information that often would not be admissible and on assumptions that could not be proved. Information in support of an order could not be disclosed to the courts without danger that it would reach the enemy. Again, there's a few layers here to unpack, but in essence, what he's saying is, I understand that there are military secrets. I understand that not everything can be in the public view. And therefore, at the same time, is problematic. Again, another star because it's relevant to modern day, unfortunately. He was this. A military order, however unconstitutional, is not apt to last longer than the military emergency. But, again, we're talking about relevancy here. But, once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, the court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law in thinking and expands it to new purposes. Again, the relevancy is very unfortunate. He's saying that in normal circumstances, a flare-up, a military incident, is temporary by default because it'll fizzle out. But as I mentioned at the very beginning of this video, legal precedent is related cases that support the decision of a future case. So based on this case, is going to inform how we rule and decide in another case. So if the Supreme Court has said that detaining people based on who their parents are racially is okay, then it can be used again in the future. And you just need one despot, one person who's a bit tyrannical, to use that to their advantage. That's problematic. I want to read that middle part again. The court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. I am recording this in June of 2025, and if you're in the future, look up LA protesting June 2025, and you'll see why this is incredibly relevant. A military commander may overstep the bounds of constitutionality, and it is an incident. But if we, SCOTUS, review and approve, that passing incident becomes the doctrine of the Constitution. The doctrine is something that is kind of in stone-ish and is not really malleable. It doesn't really move. And it's made into law. So what he's saying here is that, a military commander, he is a defender of the Constitution, but as previously mentioned, it's more about safety and protection. So he may not be a constitutional scholar. Okay? Military leaders are not constitutional scholars. They swear an oath to defend it, to the Constitution, but they don't really know it. It's the same with police officers, right? They do not prosecute. They pick people up. They do the investigations or whatever. They put together a case. But they don't understand the Constitution. They're not legal scholars. They don't know stuff. So he's saying it's a similar thing. I understand that. That's fine. But our duty as SCOTUS is to make sure that we're using our power appropriately and take into consideration how these decisions might be used by bad actors in the future. Regarding the Hirabayashi case, dealing with curfew, he says, quote, I think we should learn something from that experience. In that case, we were urged to consider only the curfew feature, that being all that was technically involved. The Chief Justice wrote in that opinion, quote, "Our investigation here does not go beyond the inquiry whether the challenge orders and statute afforded a reasonable basis for the action taken in imposing the curfew. We decided only the issue as we have we decide only the issue as we have defined it. We decide only that the curfew order was within the boundaries of the war power." And it says there italics supplied because in the original opinion, those italics were not there. But Justice Jackson wanted to point out specific things. So let's look at those italics again. Afforded a reasonable basis for the action taken in imposing the curfew, and only talking about the curfew, not about the consequences of breaking the curfew. He continues that thought. However, in spite of our limiting words, we did validate a discrimination on the basis of ancestry for mild and temporary deprivation of liberty. Mild and temporary deprivation of liberty. To be deprived of means that it's taken away. Now the principle quote, "Now the principle of racial discrimination is pushed from support of mild measures to very harsh ones, and from temporary deprivations to indeterminate ones. The court is now saying that in Hirabayashi, we did decide the very things we there said we were not deciding." What does he mean by this? He's saying that we explicitly, like he quoted, he explicitly said that in that opinion, where we made that previous decision, we specifically said we were talking about nothing except for the curfew. Nothing except for, like, multiple times. Nothing but the curfew. Now he's saying, in this opinion, we did that because we thought that that was the right thing to do, but look at how people have exploited it. This is a really, really good example of you give a person an inch and they take a mile. And just to reiterate and just to explain what I'm saying here. However, in spite of our limiting words, we did validate a discrimination on the basis of ancestry for mild and temporary deprivation of liberty. So that's an inch. They give them an inch. Now the principle of racial discrimination is pushed from support of mild measures to very harsh ones, from temporary deprivations to indeterminate ones. Indeterminate means for an unknown amount of time. You give them an inch and they'll take a mile. This is a big, big warning. And what's wild is the Hirabayashi case was just like a year previous? Look at how, they're talking about a slippery slope. In 1 year, they went from being very specific and limiting to those limits being completely trampled. Another relevant case point here. Because we said that these citizens could be made to stay in their homes during the hours of dark, it is said we must require them to leave home entirely. And if that, we are told they may also be taken into custody for deportation. And if that, it is urged they may also be held for some indetermined time in detention camps. How far the principle of this case will be expended before plausible reasons play out, I do not know. Again, relevant. Because not only is Trump taking people, he is deporting them to places unknown. He's putting them in Libya, a country that Americans aren't even allowed. I think if we are allowed to go to Libya, there are severe travel restrictions because it's so dangerous. But yeah, let's send some deportees over there. This is what he's saying. Like, oh, if we can do this, then we can do that. If we can do that, then we can do this. If we can do this, then we can do that. That's what slippery slope means. It is giving them an inch and then taking a mile. I should hold that a civil court cannot be made to enforce an order which violates constitutional limitations, even if it is a reasonable exercise of military authority. The courts can exercise only the judicial power, can apply only law, and must abide by the Constitution, or they cease to be civil courts and become instruments of military policy. If the people ever let command of the war power fall into irresponsible and unscrupulous hands, the courts wield no power equal to its restraint. I should have put a star on that slide too. If the people ever let command of the war power fall into irresponsible and unscrupulous hands, the courts wield no power equal to its restraint. Further, not only is it June 2025, it is June 14th, 2025 when I'm recording this, aka No King's Day, where there are thousands of protests happening around America today. And I think that bullet point kind of helps explain it. And again, this bullet point is from 1944, when we were in an actual war. Continued. I do not suggest that the courts should have attempted to interfere with the army in carrying out its task, but I do not think they may be asked to execute a military expedient that has no place in law under the Constitution. Again, should have put a star on this. And I'm going to say this whole thing again. I do not suggest that the courts should have attempted to interfere with the army in carrying out its task, but I do not think they may be asked to execute a military expedient that has no place in law under the Constitution. Again, if you're from the future, the main point that I'm trying to focus on here is the Marine deployment to LA. That is very, very similar here. So, we're on 51 minutes here. Again, I want to put these links in the description so that you can look at them. And in another video soon, I will read to you the second dissenting opinion from Eyebrows here, Mr. Justice Frank Murray. Again, amazing story. Like I'm calling him Eyebrows, but cool dude, interesting man, very interesting backstory. So yeah, again, please pay attention to the news. I know it sucks, but there's a lot going on, and we need to be aware. And also, a video will be coming soon about this to finish off the story. And until then, we will, for better or worse, see what happens next.